Okay, good afternoon, everyone. Welcome to another virtual event of the Bastiat Society of Washington, D.C. My name is Steve Dewey. I am the chapter director of our Washington, D.C. chapter. For those of you not familiar with the Bastiat Society, we are the public outreach program of the American Institute for Economic Research, otherwise known as AIER. The purpose of the Bastiat Society is to educate and promote the ideals of free market economics and sound money, property rights, personal liberty, and a free and civil society. The Bastiat Society has now grown to 43 chapters around the world, with 17 chapters in the United States and 26 chapters in foreign countries. If you would like to learn more about AIER and the Bastiat Society, our website address is aier.org. Today, I'm very honored and excited to have two terrific legal minds as our featured speakers, attorneys Robert Barnes and Patrick Wright. Both are real experts on constitutional law, and they will be speaking on a very important and timely public policy issue, the constitutionality of government COVID-19 lockdowns. A brief summary of our speakers. Robert Barnes is the founder and owner of Barnes Law LLP based in Los Angeles, California. He is a leading advocate of constitutional rights, and his law practice covers constitutional, criminal, and civil law. Mr. Barnes has gained national acclaim for his success in litigating cases involving several high-profile clients, including actor Wesley Snipes, former presidential candidate Ralph Nader, the Green Party, the Libertarian Party, talk show host Alex Jones, and the Covington Catholic High School students. Mr. Barnes earned his bachelor's degree from the University of Tennessee and his law degree from the University of Wisconsin. Patrick Wright is the Vice President for Legal Affairs at the Mackinac Center for Public Policy based in Midland, Michigan. He leads the Mackinac Center Legal Foundation, where he has served for the past 15 years, since 2005. Previously, he served for 3 years as a Michigan Supreme Court Commissioner and 4 years as an Assistant Attorney General for the state of Michigan. Most recently, Mr. Wright has led the efforts to challenge the constitutionality of COVID-19 executive orders issued by Michigan Governor Gretchen Whitmer. Mr. Wright received his bachelor's degree from University of Michigan and his law degree from the George Washington University Law School. Robert Barnes will start us off with a talk on the civil liberties that Americans have historically enjoyed under the US Constitution during times of national emergencies, including past epidemics, and the recent violation of these liberties under the unprecedented use and scope of executive orders by state governments in responding to the current COVID-19 pandemic. Patrick Wright will then speak on the recent court cases and the latest legal developments challenging the constitutionality of executive orders in the state of Michigan, and he will also briefly touch on developments in other states as well. Each of our speakers will speak for roughly 20 minutes each, for a total of roughly 40 minutes. This should leave us with around 30 minutes for a Q&A session with attendees. Please note that attendees will be muted throughout the course of this event, so questions from attendees will be submitted in writing, and I will read attendee questions as they come in. And now, I'm pleased to turn it over to our first speaker, Robert Barnes. Robert, please proceed.
Thank you very much. So we live in definitely in interesting times. Yet if you went back to like 1775, when Kevin Phillips is writing about the year that birthed the American Revolution, or you read Unruly Americans about how the ordinary Americans gathered together to make sure the Bill of Rights was included as part of the Constitution. During that time frame from 1775 to 1787 or thereabouts, you would have had a time period in which we went through not one, not two, not three, not four, not five, not six, but 7 pandemics in the United States. Epidemics, as they would have been termed then, because of being solely within the United States primarily. But in fact, in those epidemics were far more dangerous, far more lethal, far more perilous, 30% death rate if you got it, than any pandemic we have faced mostly since, or at least in modern times. And yet, during that time period, nobody during the Constitutional Convention Bill of Rights debate time period said, let's make sure we have a virus exception to any of these rights." Nobody even propounded or proposed the idea of using lockdowns as a health remedy that could be constitutional either. Indeed, despite going through far worse public health crises during the time period our Constitution was formed and forged, we've also experienced far worse health crises over the 18th and 19th century leading into the 20th century and the 21st century. And at no time did anybody suggest that lockdowns would be a constitutional remedy, that you could suspend the Constitution in the name of public health, that a governor could unilaterally decide that the tripartite form of governments we have no longer applies, as Patrick will be talking about later in regards to the great state of Michigan. And other governors have been doing the same in states across the country: California, Wisconsin, Pennsylvania, you name it. The governors deciding that, in fact, they're like the governors of the old English colonial era who can issue royal edicts rather than respond to the public will in the tripartite form of government. All of this is new. All of this is novel. While public health crises are not new or novel, this method of dealing with this public health crisis is new and novel, particularly also from a constitutional perspective. However, there was a past where during public emergencies, our courts have turned a blind eye to reckless and rogue government actors wishing to use that public health crisis or public emergency as a pretext, as the ones are today, to seize record-setting level of power, precedent level setting of power. So I call it the Trilogy of Infamy. Three cases during various forms of public emergency where the courts turned a blind eye, and these decisions were supposed to be zombies, dead, buried deep into the ground, and yet they have been resurrected for this new public health emergency as the excuse to seize power in ways that our founders could not have conceived or imagined. Indeed, or when and Valley Forge, when they had a smallpox epidemic raging around them, the remedy that General Washington provided was a form we would now know, or people like Alex Berenson would call, a herd immunity. He gave everybody just a little bit of smallpox, just enough so that hopefully they would be immune but not die from it. That was his method and mechanism for keeping his soldiers safe. Nobody proposed, hey, let's lock everybody down and hide in our basements. And yet that is now the official strategy in different parts of our country, including to the point, if you would have said just a year ago, we're going to live in a time period where simply running and opening your small business can make you a criminal, that we're going to live in a time period where you can't get together for Thanksgiving, you can't get together for Christmas. People would have said that's insane. That's some sort of science fiction novel. That's some sort of tin cap conspiracy theory, that we're going to have sort of de facto medical martial law in the United States. And yet it is what we have. But there is a precedent for this outside of the public health context, in the emergency context, and that is the Trilogy of Infamy. The foundation of the Trilogy of Infamy is the Jacobson decision of 1905, where a person wanted to challenge whether a particular smallpox vaccine was actually worked. Contrary to conventional wisdom, the person was not an early anti-vaxxer. The person was an early challenger of institutional science. That just because somebody put on a white lab coat, that didn't mean they magically had Milgram-like power from the Milgram experiment, where basically we figured out early on, it turns out that those who wished to seize power in the name of the state were wearing the wrong uniform. That if they had been putting on a general's uniform, many people would be skeptical. A police uniform, at least people on the left would be skeptical. A Wall Street uniform or a politician's uniform, they would each be skeptical. But you put on a white lab coat and people suddenly defer and bow. And all of a sudden, all of our constitutional principles and precedents can disappear and vanish overnight. And core rights and liberties we fought centuries to preserve and conserve be gone. And yet that's what we've seen again. That's what the Milgram experiment was, that just somebody in a position of authority in a white lab coat could get half the country to continue to shock a stranger for no reason at all. But now we're shocking ourselves in this real live Milgram experiment writ large across our country and across the West. Well, where they found legal precedent for this, they did what they resurrected from the dead, cases that in many instances hadn't been cited for decades, started with Jacobson, where someone simply wanted to challenge whether or not this particular smallpox vaccine was actually worked and whether he could be excluded from the city of Boston solely predicated on his refusal to take that particular vaccine until he could establish that it worked. The U.S. Supreme Court wrote that there's this broad authority to do whatever you want when it comes to public health in that context, and they could condition citizenship on access to it. There are always problems with the Jacobson decision, as recognized by people at the time and later, but Jacobson birthed the next horrendous decision in the Trilogy of Infamy by the U.S. Supreme Court, and that was the Buck decision, where they decided in a case that was brought with various dubious procedures, where the people who are purportedly advocating for Connie Buck really were not. And this was the case that said forced sterilizations was good. Forced sterilizations was just fine. Indeed, it was the favorite case of the Nazi Party of Germany. They would often cite to the Buck decision as their legal authority to do their particular form of eugenics. It was a horrendous decision that most legal scholars find morally repugnant and legally unjustifiable. And yet it was part of the Trilogy of Infamy, which would reappear now in this pandemic context. And its foundation was Jacobson. The third in the Trilogy of Infamy was, of course, the Korematsu case, where we decided we could, in fact, the only comparable analogy to the lockdowns we're seeing today is what happened to Japanese Americans in the Korematsu case. That's the only time where we basically took away everybody's rights, not just their speech rights, not just their religious expression rights, but their rights of self-defense, their rights to property, their rights to occupy their homes, their rights to engage in their profession or occupation without just compensation in the taking of their property. All of that happened to many Japanese Americans across the West, and the Korematsu decision greenlit it in the name of World War emergency as the justification. Korematsu has been rightly condemned as one of the most horrendous decisions, other than Dred Scott, to come out of the United States Supreme Court. But its foundation, its core, the whole basis of it was the Jacobson decision. So though that Trilogy of Infamy had mostly started to die off, the courts had started to recognize what legal scholars and legal historians noted, which was these decisions were not rooted in our constitutional founding. They were not rooted in our constitutional text. They were AWOL from our constitutional founding. They were adversarial to our constitutional text. Our founders were intimately and personally aware of these kind of risks, including war, including public health, and they chose no exception for either in the Constitution from the core freedoms that were meant to be protected from the state in all instances. And yet, so now we reach a place where courts across the country, the number one case they're citing as the basis for these public health emergency exceptions is Jacobson, more so than any other case, even though Jacobson is the foundation of those two other horrendous decisions, Buck and Korematsu. They have yet to come to terms with the fact that Jacobson is itself the virus that infected our jurisprudence in that time frame to allow an emergency exception to the Constitution. Indeed, the great Constitution of Europe at the time, considered the most democratic constitution, the Weimar Constitution, legal scholars and legal historians now recognize that its fatal flaw was that it included an emergency exception to it. And that emergency exception was abused first by certain people in power and then was used. Both that abuse justified the rise of the Nazis in the court of public opinion. And then the Nazis used it, of course, to expand and extend their power dramatically. So our founders knew why we should never have an emergency exception to the Constitution. If something is really publicly compelling to amend the Constitution, then amend the Constitution. Pass it by the Congress, pass it by the state legislatures. If it's truly so compelling and convincing that the world will recognize we absolutely have to amend our Constitution to do so, then it will achieve and attain broad public support. When they have to amend the Constitution by judicial fiat or by executive decree, then they are admitting that such a amendment would never pass. They're admitting that this is not by popular demand. This is not by constitutional process. And that is why there has to be a pushback. There have been a few conscientious courts that have been willing to do so. A federal court in the Western District of Pennsylvania in Pittsburgh was willing to stand up and detail all of the factual problems with the way these pandemic lockdown orders came about, namely that they're not really rooted in science. They're more like a science experiment than a science-driven data policy, and detailing how they offend and violate a wide range of constitutional rights and remedies. What was particularly striking in the Western District of Pennsylvania case was the governor's decision and declaration that you have no right to have a job. You have no right to work your job. You have no right to make a living. These were extraordinary statements that have not been made for quite a long time in U.S. jurisprudence. And yet the governor of Pennsylvania's official position is that you only have the rights he lets you have. You only have the rights he decides in his king-like discretion that you can exercise. This is the frightening place we are at. And as the district court said in Pennsylvania, there must be a line, and that line was crossed when these lockdown orders were issued. Now, that decision is stayed pending the Third Circuit Court of Appeals review of it, because courts have rushed in to excuse and exculpate this extraordinary invasion of privacy and privilege protected under the Constitution. Too few courts have come to the rescue of the Constitution. Too many have come to the rescue of the politicians. But we will see whether that will continue. We have encouraging decisions from the U.S. Supreme Court striking down the openly disparately discriminatory policies toward the church. Whereas somehow if you gathered in a church, because this is a unique virus, it turns out it's a corporate woke virus. It's a virus that knows that if it's Walmart or if it's a casino or if it's a strip club, not to go in there. But if it's a church or it's a small business, that's where you have to invade. And so we've had rules and policies and procedures that said the small business was scary and dangerous. The church was scary and dangerous. Sometimes even the school was scary and dangerous, particularly if it's a religious school. That's really scary and dangerous. But Walmart is totally safe. Your Costco's are totally safe. Your casinos are totally safe. Your strip clubs even are, according to the governors of both Nevada and California, totally safe. So that is the kind of insane policy environment in which we reside. The Constitution doesn't justify it, but the big question will be, do our courts, particularly the Supreme Court, step up to the plate and reverse forever and bury forever in our jurisprudence that trilogy of infamy, or do they resurrect it and allow the zombie to infect our jurisprudence and infect our legal remedies in ways that our founders would have found horrifying and horrendous? The Pennsylvania District Court judge was right. It's a line that should not have been crossed, and if we are to care about our Constitution, it cannot be crossed in the future.
Okay, thanks very much, Robert. So now we'll move over to Patrick. Patrick, please proceed.
Well, the thing that's fascinating about this is exactly the question Robert's put forward, which is, to what extent is Jacobson going to survive? And as of right now, for those of us that have been out in the field challenging these sorts of things, we've obviously had our opportunities to look at state law and federal law. I'm going to start with federal law, but I'm also going to start with my conclusion, which is federal law right now does not seem like it's going to hold up much hope for us. As we mentioned, the federal district court case out of Pennsylvania, out of Pittsburgh, has been stayed. Most of the cases that have come out haven't gone well. Starting with a trilogy of 3 Supreme Court opportunities. I refer to them by their location. They have names: Calvary Chapel, Diocese of Roman Catholic Diocese, but it's Nevada, California, Nevada, New York in that order. Only the last one had Justice Barrett on it. And what the 3 of them eventually stand for is the Supreme Court's had 3 opportunities in the church attendance phase to say you can't ban attendance at churches, or you can't tie them down to certain numbers. Twice they said, yes, you can. And the third time they said, no, you can't. This was the most recent case out of New York. But the limiting judge, the pivot point appears to be Justice Kavanaugh, who's said that he has certain red lines one can't cross. These are racial discrimination, religious discrimination, and I think he had one more that isn't immediately coming to mind. The point being is that he seems to think that there's only certain fundamental rights. He views this through the prism of our levels of scrutiny. Only the strictest of scrutinies is going to be sufficient to overcome the state interest, the same one that was put forward in Jacobson. And so we appear to have quite a bit of work to convince the Supreme Court that Jacobson is something that was incorrect and needs to be reconsidered. What has happened is, if you haven't had one of those, and this happened to a judge that we appeared in front of in Michigan, he tried to do something very similar to what the judge in Pittsburgh did. It was about gymnasiums in Michigan, gyms and fitness centers. And he said to the state, okay, show me something. Give me a bit of evidence that justifies why you are shutting down this particular system, or this particular set of businesses. Tell me why. And the state essentially said, well, you might get sick. Okay, and then he went through and did all right, well, how are they going to get more sick here? How are they going to do this? Can't you give me any evidence? Can't you back this up in any way, shape, or form? And the state really didn't meet its burden that the judge was setting. And the judge said, okay, well, I know I'm supposed to be applying rational basis. I've read Jacobson. I understand it. I just don't think you've given me anything. Ergo, I am going to hold that these places get to stay open. I'm entering in a preliminary injunction. The Sixth Circuit, 3-0, essentially put that opinion in a meat grinder and spit it out the other side. And they said, no, rational basis means what rational basis has always meant, which is, even if the state is lazy, doesn't bother to show you anything, as long as there is a justification that a judge could make up in his or her mind, in other words, the judge gets to be a participant on the government side, then we're going to find that what the government is doing is acceptable. The long and short of it is that absent very specific circumstances, right now the federal courts are not a very amenable place to fight most of these COVID restrictions. The better and more likely place that you're going to have any success is in the state courts, but that is by no means guaranteed, because I'm going to discuss two states, my home state of Michigan, where we did have some success, in Pennsylvania, where essentially the exact same playbook we used was tried and it didn't work. And what you do in these states is quite simply, you look at the state constitution, you look at the immense amount of powers that the governor has and accumulates during an emergency, and you ask this question: what kind of powers are they? And how do you turn them off? And who has the ability to control them? What the governors are essentially saying is, we have unlimited power for unlimited time, as long as we claim that we are fighting an emergency, and we consider that COVID is an emergency, that it is an ongoing, every single day, we don't know where the next outbreak could be. Anything pretty much that we do to fight this COVID is going to be sufficient to give us executive power to do what we want without going through the legislative process. Now, each state obviously has their own statutes that this is based on. You have a couple of options. In the 70s, the feds were trying to harmonize their emergency funding system. So they made the states enact a bunch of statutes that would be sufficient. So it could be under a health code, it could be under an emergency management code. In Michigan, we've had at least 4 separate statutory schemes that the governor has tried to use. So looking at what happened in Pennsylvania first, I have sometimes said that these are Goldilocks lawsuits. In other words, your timing really matters. If the situation on the ground is too hot, you're going to run into more judicial scrutiny than if you time it right and you're at a lull in the number of cases. And then if you do it too late, it doesn't matter because you've already given up all the power. So what happened with Pennsylvania is they were probably too early. Their first suit was Friends of Danny DeVito. I think it was filed in April And the obviously the COVID stuff started really happening in March, got up to through the King's bench very quickly to the Supreme Court of Pennsylvania, and they shot down all kinds of separations of powers. They shut down constitutional and all statutory arguments. They also looked at constitutional avoidance. These are all things that we eventually used well in Michigan, and they said, no, I'm sorry, you have the ability to do this. We're uncertain what's going to happen. COVID's scary, and this needs to be done. The second Pennsylvania lawsuit was a suit, and obviously the governor and the legislature are separate parties. And the legislature was trying to regain control and said, okay, we've turned on the emergency switch. We had a statute by which you could grab emergency powers. It says here in the statute that if we enact a resolution, we can turn off your emergency powers and we can go back to the constitutional order that we've had for 2 centuries, where we have this whole thing of we present things to you, you sign them, vetoes, legislation as opposed to edicts. And what happened there was based on the legislative veto case line of cases, Chatta and so forth, the Pennsylvania Supreme Court said, sorry, the statute may say that, but really what it means is that you have to do this through legislation. And if the governor vetoes it, that's just too bad. You've got to get to 2/3. Otherwise, the governor keeps these emergency powers and still to this day has these powers. There have been a couple of federal suits. Robert referenced one. There was another one that came out of the Middle District of Pennsylvania. The second one was just a denial of a TRO. It hasn't been appealed yet. And as we indicated earlier, the Wolf decision out of Pittsburgh, which was a great decision, fun to read for those of us that are free market libertarian based, it was like, oh, how wonderful. It got stayed, I think, within 3 days. So that's still waiting for a decision at the Third Circuit. In Michigan, we had a little bit more luck, but maybe it was based on the composition of our court, which has since changed in this last election. We had 2 statutes that the governor was relying on. One of them was enacted in 1945, which is after a bunch of race riots in Detroit, and seemed to deal mostly with police matters. Another one was one of these federal statutes that I was talking about. This came out from after 1976. And this one did have a time limit on it. And so what happened is our governor said, I want an emergency. Nobody denied that she had one in early March. She said, I want an extension. Our legislature gave her a 23-day extension. She said, I wanted a 90-day extension, and our legislature essentially said no. Now, because we had it set up that it required a resolution to continue as opposed to it required a resolution to stop it, we didn't run into the legislative veto problem. But the governor still said, well, that's fine and good. The emergency's over. I'm issuing a new emergency 1 minute after that last emergency just ended. And it was at this point that we said, okay, guess we're going to court. And we brought a separation of powers non-delegation claim. And this was what it was eventually victorious for us, although it was a 4-3 decision on this particular portion. What the governor did was she was claiming that she not only had the power to fight COVID, but she also had, and this is amazing, she had the ability to fight the downstream economic effects of it. So because our economy had been obviously impacted by nobody working and nobody traveling and everybody being stuck in their house and unable to visit anyone for Easter, she was saying, well, that's affected our economy. And until we've cleaned that up, I get to have emergency powers. And then until we have the vaccine figured out and until all of these things had occurred. So I could be doing this for years at a time. And the Michigan Supreme Court, based on some administrative law decisions like Gundy, which have hinted at the fact that after 7-8 decades, the United States Supreme Court might finally be willing to tackle the monster it created in allowing the administrative state to do what it wants, when it wants, how it wants, with very little guidance. Our people borrowed some of that language and said, okay, under Michigan law, this is just too much for too long with too little rules. And they overturned the governor's ability to do this. She had issued at the time, we were at October, I think 2nd was the day our decision came out. We had started March 10th. She was averaging an executive order a day. And we had also had, I believe we got over 500 FAQs interpreting these various executive orders. Nobody in the state could keep up with, and this includes us who are attorneys and following it day by day, could keep up with what the law was, what was legal, what wasn't legal. She had also tried to do something else that we were able to stop in court, and that was she tried to merge some of the power of the administrative state. Our two statutes limited people to a $500 fine and misdemeanor charges. She tried to merge that with our OSHA, our state OSHA provisions, which gave her the power to do a $5,000 fine a day plus a 3-year felony for each and every violation. It was claiming that every time somebody violated one of her executive orders, that this was a separate legal charge that could lead to convictions. We got a different judge to stop that. So we've had some success with that. However, almost immediately upon our decision, the governor pivoted. I said we had done our stuff through the emergency management codes. We had 2 separate ones. And then our governor shifted to the health code. And one of our 4 justices had indicated that this was a possibility. And the governor has taken advantage of that. And so they had 11, 12 different categories of extreme powers that she had claimed for herself under these emergency management statutes. She's probably boiled the frog sufficiently to where she's at 5 or 6 of them now, and is, continuing to argue bit by bit that maybe she could get that next one too. And again, this goes back to some of the Goldilocks theory, which is in part what we need to litigate this are the egregious facts. The more power she claims for the longer she claims them, particularly if we're at a lull in cases, we're going to have better shots at doing this. To date, amongst the states, the only really 2 states that have had any luck at this are Wisconsin, which fought them on administrative procedures grounds and essentially with some sprinkled in separations of powers behind it, but essentially said, what you did, you didn't do properly through the Administrative Procedures Act in Wisconsin. We've had success fighting it on the separations of powers constitutional ground in Michigan. Everybody else has blood on their forehead from running into a wall. We just haven't had that many court decisions that have gone our way. We need to figure out ways to do it because, as Robert has indicated, this is just unsustainable.
Sorry, I was on mute there. So any questions? Oh, okay. I've got some questions here from our attendees. Okay, this is a question from Ryan Higgins at AIER. The question is, if COVID is emergency, why is FDA taking its time to roll out a vaccine? Also on gyms, since 90% plus of the people dying from COVID-19 have comorbidities, isn't the problem that the problem of people not going to gyms? And one is not going to mandate that people go to gyms, but to close gyms in response to a disease that has serious effects, principally those who do not maintain their physical health. Seems to be irrational. So I guess it's 2 separate questions. One is about closing gyms. The other one is about the FDA taking its time to roll out a vaccine.
Well, I do have one quick point on vaccines. In our research for this, we found that the fastest ever vaccine was 4 years for measles. And so if we get that we have a COVID vaccine within a year, that'll be great. But this was part of our big concern was the governor was claiming, hey, I've got to do this until this vaccine is in place and effective. We can talk about the political release of the the vaccine news. I guess they couldn't, they thought that doing it the Wednesday after, the day after the election would be just too obnoxious. But, we still have to get it done. We still have to actually prove that it works. I hope the FDA moves it along as fast as possible. It has not been a speedy process before. And to the extent that we have people that claim that they have powers until such time as they feel that this is done properly, it just impedes all of our rights.
Right. And you want to touch briefly on Jim's?
Yeah, I mean, I try to the greatest extent possible as a matter of litigation strategy to stay away from the epidemiological questions. I do not believe, one of the arguments we made and lost on, by the way, was that we are no longer in an emergency. We're in an extremely important situation. For our litigation purposes, we left a portion of an emergency statute in place because I didn't want the court to feel that the next time that there's a hurricane or a flood or something, that we don't have some level of state law tools in place. What concerned me most was the idea of this occurring forever, and more importantly, the next matter. And that is, okay, on the American left, we are told time and time and time again that climate change is an emergency. Okay, so what happens when a governor in Michigan tries to say, I need to use this power. I can't wait for the legislature to agree with me. I just get to run roughshod over this, or race relations. Or if you want to use a more conservative position, what happens if somebody comes in and says, abortion's a big problem in this country. We're losing 1 million people a year. We have to stop it. So the idea of throwing, essentially placing years long, the separations of powers on the shelf for whatever the emergency de jure is, just is something that is quite frightening. There's enough problems in the current implementation of all these, let alone that what governor isn't going to want to be able to shut out the legislature on the next subject matter in the future.
Okay, I've got another question here from Michael DeGrandis. Michael is actually with the New Civil Liberties Alliance in Washington, D.C. He's an attorney there. So Michael's question is, as wrongly decided as Jacobson may have been, does it apply in the context of gubernatorial COVID-19 executive orders? And if a governor is setting public health policy and dispensing with the law, as argued in my Massachusetts case, does Rosiers versus Baker, isn't there a serious separation of powers or non-delegation problem? And then he goes on, even if Jacobson stands for the proposition that legislatures have plenary authority to exercise the police power, it doesn't follow that chief executives may exercise the police power. Indeed, doesn't Jacobson cut the other way and support separation of powers challenges? Detailed question.
Yeah, I don't want to hog the time here, but I'll answer my portion of it. We tried and looked at a police power question in Michigan. The statute that we had discussed public safety, but not public health. One of the justices picked up on that. We tried to make the argument that public health would include things like a pandemic and public safety, and that this was really a riot statute and not any catastrophe or disaster that you could try and imagine statute. We didn't get anywhere with that. And to date, the Supreme Court has said they're going to look at this in the classic tiered scrutiny analysis, which is you take your constitutional right, you measure it against the state interest, and we see which one comes out on top, and very few federal constitutional rights to date are coming out on top.
Okay, Robert, did you want to chime in on that at all?
I mean, there's good aspects, and there's two fundamental issues with what's going on. One is just the evisceration of constitutional rights and liberties in the name of a self-declared emergency. And the second is separation of powers issues, because the source of these rules, the source of these restrictions, the source of these regulations in most contexts is unilateral executive action, often against the wishes of the legislature, which is what Pat is talking about. And where there's been some success, the only place where there's been, well, other than the Pennsylvania decision that got stayed, where there's been any success legally has been in the separation of powers context, aside from the recent Supreme Court case on religious discrimination grounds. And even there, they limited the scope of their ruling. In other words, it applied to, you can't target churches explicitly for discriminatory treatment in the guise of a pandemic. But they didn't say you couldn't oppress everybody equally yet. And you know, that's still a core problem. So they just got rid of the more absurd versions of these rules. I thought at least Roberts would be embarrassed and humiliated by his prior decisions in the church cases after a whole bunch of questionable activities happened in California and other places. Well, once they greenlit all the BLM riots. So once they said magically, if you're part of a BLM movement protest, then COVID, again, it's corporate woke, so it's not going to infect you. But if you go to church and if you sing hallelujah, well, there's real problems there. That's how that virus tends to spread. So I thought someone like Roberts would recognize how embarrassing it is that he signed off on a decision that just a week later Newsom greenlit, and all the Democratic governors and mayors greenlit the participation in the riots or the protests, whatever you want to call them. But he didn't. And I think this reflects a deeper problem, and what Pat's talking about too, is our judges come from the professional class, and I think there's a gap, a divide, an increasing divide between them and ordinary everyday people. More and more of our judges have no experience running a business. More and more of our judges have no experience, frankly, having a real job beyond being a lawyer. And I say that as a lawyer. But, you know, these are people who don't understand the pain they're inflicting and the dreams they're crushing overnight. I mean, these small businesses that got wiped out most likely will never come back. For those who can get extensions of credit and those who can get government relief, it's a different dynamic, but that's disproportionately the well-connected and the well-to-do. So the people who are really victimized by this are your small business, ordinary, everyday workers. That's who's getting hammered. It's a massive redistribution of wealth, but it's to the tech stocks and to those companies from small business America. Even in the restaurant space, it's from mom and pop to the cheesecake factories that can survive and sustain this. But I think part of the problem is people like Roberts reads the New York Times too much. And, like, that's his worldview. He doesn't understand. You know, it's not like House of Cards, where at least the Kevin Spacey character talks to the local ribs guy in town to try to stay connected to ordinary people. Our judges are increasingly completely disconnected from everyday ordinary people in a way that almost bred the kind of decisions we got with Buck and Korematsu. And I think what Pat is also saying is very important for people to understand. They're not really following logic or law. They're following emergency. We better protect and make sure they have all the power they can. If I do anything that interferes with their power, I've probably killed grandma. That's the mindset these courts are applying, rather than this is a perilous precedent that undermines all core constitutional liberties that could end the constitutional republic tomorrow if we let it be permanent precedent. And that's why what Pat's saying is absolutely right. We have to time these suits to give us the best chance of success. And the reason, like I was telling people early on, wait for a while to file suit until this dies down, then challenge it when courts will feel like they're not interfering in the emergency, but set rules that stop this from reoccurring, because that's the great danger. If we have an emergency exception to the Constitution everywhere, an emergency exception even to separation of powers everywhere, then our Constitution is more at risk than the Weimar Constitution was. And we saw where that ended up.
And the other thing that's, the good point about this is if you look at the Roman Catholic Diocese decision, you can see this. Gorsuch is essentially espousing this view that Robert's exactly talking about, which is you can't put the darn Constitution on it to have it take a nap, a siesta, a vacation. I can't remember the exact term he used. And, there's a little bit of a personal tone to both Roberts and Gorsuch's concurrences and dissents in that case. They kind of go at each other a little bit. And Gorsuch is just a touch, you can, read the tea leaves, upset that they've done this with Jacobson in the first place. And I think, he's at the enough stage. But 4 is not 5. And until Justice Kavanaugh is brought along, and I think he's the holdout. I don't quite know where Justice Barrett is. I think we're going to probably need one more decision to figure her out. But until he's brought along, this is the world we're going to live in, which is that these governors are going to be given tremendous powers, and the federal courts are not going to be a place where you can seek remedy.
Okay, I've got, I got some other questions here. So another question here, this is from A.B. Friedman. Please discuss the plaintiff as a variable on the federal level. It sounds like discriminatory impact matters. So churches or racially protected plaintiffs might have different luck than a small business on separation of powers. Would it matter if the state?
Not necessarily on separations of powers, but this is the whole tiered scrutiny thing. The United States Supreme Court essentially says some constitutional rights are greater than others. And as Robert is indicating, the right to have a job isn't even listed as a constitutional right. So race discrimination gets the highest level of scrutiny. Religious discrimination gets the highest level of scrutiny. Gender gets a middle. There's some other middles. And then everything else gets thrown in this bucket called rational basis. And one of the great frustrations for people that believe in economic liberty is that this is where I was talking about earlier, where the judge essentially has to help the government. When you do rational basis, it is the presumption that that law is valid, that it is just a policy choice being made by the legislature and cannot be challenged unless it is absolutely void of any potential justification for it. So even if it's a bad justification, even if the state didn't put it forward, when you talk rational basis review, that's the standard that the state has to meet when they're trying to overcome something. So with your businesses, those are going to fall under rational basis. And that's what happened in the gymnasium case I discussed earlier. The judge said, you gave me garbage. I'm not going to rule in your favor. And the Sixth Circuit ate him up and spit him out. Okay. And so you will have opportunities to win if you are a church being discriminated against, if there is race, maybe content on your speech. These are all things that Kavanaugh has said is going to trigger his level of scrutiny. Whether or not that's right or not, that's the world we live in.
Okay, I've got a couple of good questions here from Wayne Abernathy. Wayne, thanks so much. Wayne is one of our regular attendees, retiree from the U.S. Treasury Department, and always appreciate Wayne's participation. So Wayne's got a couple questions here. First one is, back with a full SCOTUS, are we seeing an evolution in the approach and views of the now, once again, full SCOTUS? And then he has a follow-up question.
So, I mean, a couple of things. One, on the prior question, Pat's definitely right that picking the plaintiff is critical. I brought suit and I picked cases that were the most extreme examples. So I sued for a church for a mother and her daughter who wanted to take her daughter to Easter service. That was a drive-in church service, and the lunatic mayor of Chattanooga banned even that. And it was in Chattanooga, it was in Tennessee. So I was going to get some friendly courts, and I did that there. And Michigan brought a case where someone was just trying to travel between homes to meet family. When the original order banned that from occurring. Brought suit in Virginia where they weren't allowed, where they were still requiring people to witness and in-person circulate if they wanted to be a third party on the ballot. Roberts, by the way, has issued some overtly hypocritical rulings. Somehow it's completely okay to require that people continue to circulate petitions to get on the ballot in person, that somehow is magically not a risk. such that you can compel standards that are ridiculous in the context of a pandemic, where you just can't get that many signatures, but then turns around and says, oh, this pandemic's so scary, we got to give them discretion to discriminate against churches. So that's some of the egregious examples we've witnessed. But in almost all of my cases, they settled. So they recognized that the facts looked really bad and were really egregious. And so they were smart. They didn't allow those cases to move forward. They made sure those cases weren't going up the appellate food chain. So I do think continuing to pick good cases makes sense. As to the SCOTUS, what Pat says is right. What we really have is a 3-3-3 split. It looks like Gorsuch, Thomas, and Alito are going to be good, and they're Alito recently made comments to this effect. As Pat noted, Gorsuch has been basically waging war against Roberts for 6 months now on this, and Thomas is probably going to be good on this, given his statements to date. So you have three, I think, who are really willing to say Jacobson shouldn't even apply. They made some comments like that in the sort of concurrent / dissent in the prior case. I think it was the Calvary Chapel case. Then you have three justices on the left who are let them do whatever they want. It's been sad to witness. I've been working with Robert Kennedy Jr. to try to create cross-party alignments on some of these lockdown suits because he's bothered by them in a wide range of contexts, because it's been disappointing to see almost no of the traditional left voice concerns about our constitutional rights anymore, just in the name of a public emergency. But right now, that ship has sailed. They've shown no interest in helping out the three, Sotomayor, Kagan, or Breyer. Now, the three in the middle are really still unknown. I mean, Roberts has leaned deferential, but has kind of hinted that he won't be deferential forever. But I think that's what's frustrating Gorsuch. His deference keeps going on and on and on. Barrett, a good ruling on religious discrimination. She cited Jacobson favorably in a Seventh Circuit case in a political context in Illinois before she was on the bench, before she was on SCOTUS at the Seventh Circuit level. Maybe that was just following what happened in Calvary Chapel. Maybe that was a sign of problems to come. I think she'll be very good on religious and self-defense issues. I'm not so sure she'll be great on lockdown issues writ large. But so she's an open question, as Pat noted, and Kavanaugh is an open question, as Pat noted. So we have, we just need two of the three to join the party, and we're in business. But whether they will is an open question. The best case to challenge the whole lockdown, in my view, would be a church-related case, because that's the best one that you're going to get either Kavanaugh or Barrett to join.
And in the States, one of the things that we did, because we were very conscious of the question of who we were representing and why, the state interest that the government was putting forward is we were saving lives. That's their claim. So we felt it was very important for us to find health providers that were being frozen out from seeing their patients. And so we were able to do the same thing. There's come to be some evidence that, heart attacks, diabetes, cancer is on the rise, because we essentially had people in Michigan, 10 million people that were frozen out from seeing their doctors because we were afraid of that we needed to flatten the curve, and we were afraid of what was going to happen. So again, the optics are very important. Justice is supposed to be blind, but I guarantee you, and this is why I'm calling them Goldilocks suits, and Robert seems to be of the same mindset that I am, there is a lot of peeking going on through that blindfold right now as to what the facts are on the ground.
Okay, I'm just going to also read to you a second question from Wayne Abernathy. Then I've got a couple more really interesting questions from a couple other people. So Wayne's second question here, would you speak a bit about intra-state differences? By that, I refer to local governments who differ from their governors in application of rules and restrictions, sometimes greater, sometimes less restrictive, in their counties or cities.
Well, this comes back to the question of where the governor or whoever is getting their power. What is typical in health codes is that you have quarantine orders that localities are permitted to do. So in Michigan, we have our Department of Health can declare something. We also have each county has its own health official that can handle their localized stuff. And so what I found after we won our case here in Michigan, I kind of analogized it in part to a grease fire. We threw some water on the big one, And then I ended up with 83, that's how many counties we have in Michigan. I ended up with 83 different jurisdictions now thinking that they were in control and that they could set all of the various and sundry things. So, you know, your Wayne County where Detroit is, Oakland County, these are big counties that carry a good portion of Michigan's population. But again, you're going to have to look state by state as to the source of the power of whoever is trying to issue these edicts. And where if most of the time it's being done through health law, through the health code, they're going to have things that give discretion to local health officials. So you can end up with differences within various states. You know, we argued that there should have been some on when the governor was in charge, that Detroit was not the same as the Upper Peninsula of Michigan, in that she wasn't doing a very good job of understanding that, of recognizing the difference between urban and rural communities, and that the decisions she was making to harm businesses in the rural communities didn't make any sense because that wasn't really where the virus's threat was at the time. So that is how you can end up with these different things. Unfortunately, then you have to challenge them on a locality by locality basis if that's where the power is coming from. And then that means that people like Robert and myself have to be in not just 83 places in Michigan, but you know, however many counties there are all throughout the country. It's tough to be at all places at all times.
Okay, great. I've got another question here. Another one of our regular attendees, James Bond, his question, by the way, that's not James Bond as in B-O-N-D, that's James Bond as in B-O-H-N. James, thanks for your question. He says, taking claim question, my theory is that the plaintiff would have a claim against government, not the tenant, in the context of a rental moratorium. Do you have a comment on that?
There's a range of suits being filed in California about this because they've issued every kind of moratorium known to man there. So there's issues about the eviction moratorium, whether that's a taking. There's and I saw an earlier question about this. There is takings takings lawsuits pending in Pennsylvania and other places. They haven't gone very far yet. They haven't been shot down yet either. The Supreme Court did just take a regulatory takings case that may expand the doctrine of regulatory takings, and that's really necessary to piggyback on to have some success using the takings jurisprudence, because that, at least in theory, is a fair constitutional remedy that can be appealed to the courts of, okay, really the emergency made this necessary, but at least compensate the people who disproportionately feel the pain from it. And so hypothetically, that could appeal to the political preference of the court if they want to preserve some constitutional remedy, but provide the power needed to act in the case of an emergency. It's not my preferred remedy, but I mean, because there is no compensation really for First Amendment violations, certain Second Amendment violations, Fourth Amendment violations, certain kinds of Fifth Amendment violations. But it would at least be a remedy in the economic space. And I would love to see regulatory takings law expanded, because Pat was talking about the Leviathan that has become the administrative state encroaches upon core economic liberties on a daily, everyday basis to such a degree. You have a governor like the one in Pennsylvania saying, you have no right to even continue to work. You have no right to a job. You have no right to an occupation. You have no right to be able to own or operate your own business. That's a very frightening place to be, and one I'd like to see not become the judicial legal reality of our world.
I've been asked a number of times in Michigan, okay, you guys won on a constitutional claim, where's our damages? And part of the problem is this. I've got 10 million people that are plaintiffs that would be suing 10 million people for damages. Because essentially what happens is you're suing the state, you're suing the government, and all you're doing is maybe moving some money around. Now, there clearly are people that are hurt more by this, but I think it is going to be very difficult for any court to allow damages this broad based on this kind of matter. So theoretically possible. If I brought Richard Epstein in here, could he try and convince me? Yeah, I'm sure he could. But I don't see that many damages claims are likely coming out of the backside of this.
Okay, I got another question here from Jay LeBlanc. Jay, thanks for your question. His question is what Robert just mentioned about a little while ago about the court being unwilling to take action if it might risk harm to individuals. Like if I remove lockdowns, someone might get COVID. Isn't the same argument that is now discredited in Korematsu, the potential threat of the Japanese didn't justify the immediate impact of the loss of rights?
I mean, that's how Korematsu has been treated, and yet somehow its ghost has reappeared with a new emergency, and arguably less compelling. I mean, you could make an argument for Japanese plans, and we were in the middle of a war with Japan, that some would say were stronger arguments than some of the provisions we're putting in for COVID. But putting that aside, and that it was war, not a virus, we've never reacted. From an epidemic. I'll get the word wrong, but
epidemiological.
Yeah, exactly. From that perspective, we've never done this before. I mean, in human history, we've never done lockdowns before. That's why when I was researching it from a legal perspective, I was looking for whether this kind of challenge had happened. And you had Jacobson and vaccines in that context, but nothing like this. They'd never said, you know what, let's take the Japanese detention camp model and let's apply it to the entire country in the name of a virus. That combination hadn't happened. So I was frankly kind of shocked by the scale of it. But knowing the legal history, it was clear that there was this is the greatest threat to the Constitution, in my view, legally in our history, because those cases because this is a complete abandonment of almost every constitutional principle. Not only no Bill of Rights, no separation of powers. And
let's remember this about the separations of powers. I mean, if you're a Antonin Scalia fan, he has a speech. One of his favorite speeches was to, his speech trick was to go and pull out and he'd read you from the Soviet Constitution. He'd read you their Bill of Rights. And you would be surprised at how many of them mirror what you have in the American Bill of Rights. And his point was that it is the structural portions of the Constitution that provide you with the protections you find in the Bill of Rights, that without the structure, the Bill of Rights is meaningless. And, this is essentially, we're testing that very theory right now. And I don't like the results.
Okay, let's see, got another question here. This is from JP. His question is, assuming that we get past this current crisis, what sort of legislative changes do you think would help prevent similar abuses in the future?
For me, looking at this, I've come up with a couple of them. I think that there needs to be a heightened threshold to declare an emergency in the first place, and it probably needs to be a two-branch decision. Both the executive and the legislator have to say something. I think there has to be time limits on it. I mean, it can be redone, and maybe it's through a lapsing period. I would like to see that if you're going to have that you have to do more legislation within a certain time period. I find it very difficult to believe that we can be in an emergency now for 240, 250 days. Is this an extremely important question? Yes, I am willing to see all of that. I'm not going to sit here and try and fight the science on this. I'm going to say people are dying, fine. But it is a situation of, is this something that requires absolute control and immediate day-to-day decision-making taking out of this process that has worked for us for 2 centuries? And the answer to me to that is no. So there has to be, I think, a harder time starting an emergency, and there has to be an easier way to terminate one.
That makes sense, yeah. Okay, I've got another question here. Let's see, this is Okay, another question from A.B. Friedman. This is interesting. So we have civil rights legislation. He's asking, what do you think about a federal Economic Rights Act to parallel the Civil Rights Act to protect the liberty of commerce as a civil right? It's kind of an interesting.
Well, yeah, well, I'm for definitely expanding protections wherever we can legislatively to limit this from reoccurring in the future. But as Pat notes, if they're willing to disband the Constitution, which is already supposed to be a restriction on these behaviors, then legislation that offers a limited remedy, because the problem is judicial enforcement right now is as much as anything. I mean, we put in separation of powers to structurally prevent this kind of event from occurring, and yet they're ignoring the separation of powers in most states and most jurisdictions. So even when they're being openly hypocritical, even when the evidence doesn't support what they're doing, even when there's more and more outrage over it. I'm all for additional legislative reform because it can't hurt in all likelihood if it's done correctly, but it's not necessarily the remedy when courts aren't even enforcing the Constitution, either of the state or of the United States in many of these cases.
Yeah, okay. A question that I have for both of you. So I'm not an attorney, but from what I've read, a lot of our states have state laws that do provide for emergency decrees to give state governors, the ability to impose an emergency decree, and state laws, I think, typically have a time period for emergency decrees of
About 4 out of every 5.
About 4 out of every 5 states.
Yep, it's about 40 of them have a time limit and 10 or 11 don't.
Okay, and those time limits are, I take it, from like 14 days to 30 days? Typically?
I think you can get up as high as 60 to 90, but they're generally in the 1 to 3 month time range.
Okay, so I guess a lot of these governors just keep extending the decrees.
Well, and this goes back to one of the questions of how do you turn it off? All right, there's a couple of hypothetical situations where you have opposing political parties. You're probably going to be able to find the conflict earlier. But I dealt with one of these panels where we were out in Hawaii, and they're the governor and the legislature are the same political party. They haven't had any trouble getting their extensions. They've just been perfectly, the legislature, as is many legislatures these days, is perfectly willing to let the executive go and do this, occasionally pipe up and say, I wouldn't have done that, and then, protect their jobs that way. I do think that the other thing that's causing some problems where you do have different parties is you have this legislative veto question, which has applied itself in Pennsylvania. I know that it's applied itself in Oregon as well. And that's the question of, okay, now you have somebody who wants to turn off these emergency powers. How do you do it? And if it turns out that you have to present it to the governor, well, guess what? You're getting vetoed. And if you don't have 2/3 of the legislature with you, which I don't think there are many states where we're at legislatures that have that kind of majorities, then the governor is just going to keep running and running and running and doing whatever he or she feels is necessary.
Right. Okay, so we're close to our 75-minute agenda. I think I can get in one more question, comment. This is from Alina. So this is, I guess, more of a comment that she's making, and I guess she's asking if you have a comment. She says, commerce is a civil right. Love it. Although, isn't that under the pursuit of happiness?
Well, and this is getting to some stuff I haven't done in a while. I did some Claremont work, which is they have always tried to read the Constitution through the lens of looking at what the Declaration of Independence has said. Commerce in United States constitutional law has mostly been the right to contract for individuals. That essentially died in the mid-30s. And what's happened is that commerce has come to mean anything that gives the federal government power. It's a lot different than the framers probably intended it. It has had severe consequences in how our lives go about. Be that as it may, I ache for the days of only federal power, given what we've been seeing the last 8 months. So there's definitely some importance to that. This is part of what Robert's talking about with the right to get a job, to have a job, and the courts don't seem to accept that as a fundamental right, because they just don't want to get involved in day-to-day legislation and make economic choices.
Okay, so I'll just maybe wrap it up with one more question that I have. When do you think, when do you think one of these cases may end up with the U.S. Supreme Court from the states?
Well, we've already had 3. I mean, what you can accelerate them by using the preliminary injunction temporary restraining order process. When we're going to get one, maybe more evidence-based, I don't know. I have thought about, and I imagine Roberts has crossed his mind as well, about having some sort of Scopes monkey trial with the science, where you actually do go through, and this is a little bit of what happened in Pittsburgh, where they tried to say, okay, show me your best math. That would be the epidemiological fight. I will say this as a 501c3 outfit, that has to finance this sort of stuff. I would not want to be the one having to depose 500 government experts and running through all of this, presenting it over months probably, and essentially, getting my own epidemiology degree in trying to fight it. So I don't know when that day is going to come, but I don't feel like it's going to be before we start getting vaccinated.
Mm.
That's probably true. And my hope is, or our best hope, I think, is that the Pittsburgh case ends up in front of the Supreme Court. It has the best factual record. It is the best, broadest challenge. He's trying to reinvigorate some old law, old constitutional principles on right to an occupation. I would like to see that case in front of him. And I think if the Supreme Court is inclined to really meaningfully restrict this in the future, that's the kind of case they would take, because it has the most thorough factual record developed. So hopefully it will, but we definitely depend on SCOTUS, because the rest of the federal courts have almost universally shut this down.
Wow. Okay, well, I see we're at our time limit, and I just want to thank Robert and Patrick for your participation. Really appreciate your taking the time. We're very grateful to hear your expertise. And thanks to our attendees for attending, and everyone have a great rest of the day. Thank you.